Good morning. I hereby call to order this 10th meeting of the Pennsylvania Public Utility Commission for the year 2018 and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. The first matter on today's agenda is the approval of the minutes for May 17, 2018, and I will call upon Commissioner Sweet, who is the editor.
Madam Chair, I've reviewed the minutes of the public meeting of May 17th, 2018, and move that they be approved as submitted.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion? Any further edits? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. And as I continue to remind people, a reminder of the safety information that is in the agenda, at the bottom of the agenda, in the case of any emergency. Now I will call upon our Secretary of the Commission, Secretary Chiavetta, to lead us through today's agenda.
Good morning, Madam Chairman. Good morning, Commissioners.
Good morning.
Your various bureaus and offices have prepared the following agenda for your consideration. Beginning on page 1, we have a case of special interest. It is recommended that the Commission conduct a binding poll in the matter of the Newtown Artesian Water Company's request to increase its distribution system improvement surcharge cap. Please note the polling sheets reflect a summary of the exceptions and reply exceptions filed in response to the ALJ's recommended decision. The first issue is the denial of request to increase the disc cap.
Commissioner Coleman.
ALJ.
Commissioner Sweet.
ALJ.
Commissioner Kennard.
Company.
Vice Chairman Place.
ALJ.
And I will also be voting with the ALJ.
The second issue is the statutory and legislative intent for the disc cap increase.
Commissioner Coleman.
ALJ.
Commissioner Sweet.
ALJ.
Commissioner Kennard.
Company.
Vice Chairman Place.
ALJ.
And I also will be voting along with the ALJ.
And the final issue is the purchased water adjustment clause and fully projected future test year alternatives.
Commissioner Coleman.
ALJ.
Commissioner Sweet.
ALJ.
Commissioner Kennard.
ALJ.
Vice Chairman Place.
ALJ.
And I also will be voting along with ALJ.
Madam Chairman, this concludes the binding poll.
And is there any further comments or comments to be had on this case?
I have a short statement, Madam Chairman.
Commissioner Kennard.
I fully support the DISC legislation and agree that it is important to encourage needed investment in infrastructure in the Commonwealth of Pennsylvania. Act 11 of 2012 allowed all fixed utilities to file a distribution charge, improvement charge, but the cap for water companies is 7.5, and it's inappropriate, in my opinion, to apply the precedent and the thought process that applies to the gas and electric industry, who have a 5% cap. The company here is asking to go from 5% to 7.5%. In my opinion, if they're going to spend the money, they should be allowed rate recognition, and we shouldn't put arbitrary rules in their path. Therefore, I would vote to increase the DISC rate for Newtown Artesian Water Company to 7.5%.
Any further discussion? Thank you very much.
Turning to page 2 of the agenda, it is recommended by Director Kelly Monahan and the staff of the Bureau of Audits that the Commission release the audit report of the PECO Energy Company.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 3 and matters presented by Acting Director Marinko and the staff of the Office of Special Assistance, it is recommended in an omnibus motion that the Commission adopt both of the items appearing on page 3.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 4 of the agenda, it is recommended the commission adopt the proposed opinion and order regarding the Bureau of Investigation and Enforcement versus Conestoga Tours.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Any discussion?
I have a motion, Madam Chair.
Commissioner Sweet.
I ask that my motion be placed upon the record as if I had read it in its entirety. 2016, pursuant to a formal complaint filed by the Bureau of Investigation and Enforcement, the Commission canceled the Certificate of Public Convenience of Conestoga Tours, Inc., and imposed a civil penalty for failure to obtain proof of insurance, or to maintain, proof of insurance. Both the complaint and the order were returned as undeliverable, but eventually the follow-up reminder made its way to another Conestoga company, which forwarded it to the correct individual. Conestoga Tours has ceased operations as of the end of 2015, which is why it did not renew its insurance at that time, and they are asking that we rescind the civil penalty, which is recommended to be imposed. A holder of a certificate of public convenience that operates in the Commonwealth must be properly insured at all times in order to ensure the safety of the traveling public. I remind all CPC certificate of public convenience holders that they do have a duty to inform the Commission when they cease operations, as without that notice, the Commission cannot immediately tell whether the holder has ceased operations or has run afoul of the requirements that they maintain appropriate insurance. Therefore, there is a reason we want the notification. However, in this instance, Conestoga seeks only the rescission of the civil penalty, as it has ceased operations and did not at any time operate without proper insurance. Rescission of the civil penalty is consistent with other Commission actions under similar circumstances. Therefore, I move that the petition of Conestoga Tours, Inc. for reconsideration of fine imposed be granted, that the Office of Special Assistance prepare an appropriate order consistent with this motion. Thank you.
You've heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Vice Chairman Place. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, if there's no objection, we'll take the previous roll call. Seeing no objection, the matter as amended passes 5-0.
Continuing on page 4, it is recommended in an omnibus motion that the Commission adopt the remaining item on page 4 and all of the items on page 5, ending with the complaint of Debbie Huey versus the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 6, it is recommended that the Commission adopt the proposed opinion and order in the matter of Eartha Page versus the Pico Energy Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion?
Chairman, I have a statement on this matter.
Commissioner Coleman.
I'd ask that my statement be entered the record as though I read it in its entirety. In this proceeding, the complainant has requested that she be given a payment arrangement for an outstanding balance to facilitate the restoration of utility service. The presiding ALJ dismissed this complaint with prejudice due to the failure of the complainant to attend in-person evidentiary hearing. This was the second scheduled hearing for this matter, as the complainant had been granted a continuance due to a transportation problem at the time of the first hearing. The complainant filed timely exceptions in which she alleged that she was present at the Commission's waiting room at the time of the hearing, but no one came out to escort her into the hearing room. She also alleged that she attempted but was unsuccessful in contacting anyone at the Commission's office. PICO filed reply exceptions in which its counsel maintained that PICO employees checked the waiting area before the hearing started at the ALJ's instruction and again after the hearing concluded, and that no one was present at either time. PICO's reply exception is accompanied by a verification signed by PICO's counsel for this case, which states that representations made by her are true and subject to criminal penalties for false statements. Counsel for PICO has appeared before the Commission's ALJ on a regular basis, litigating proceedings for a number of years. The proposed opinion and order reverses the initial decision and remands the matter back to the Office of Administrative Law Judge so another hearing may be scheduled. However, I agree with the ALJ's initial decision to dismiss this case. I cannot conclude that the complainant's non-attendance was unavoidable and that further proceedings will not prejudice both PICO and the public. Finally, PICO has represented in its answer that the entire outstanding balance is composed of customer assistance program arrearages and therefore are not eligible for payment arrangements as a matter of law. If this is true, the Commission will not be able to provide this customer the relief she's requested, even if she does attend a next scheduled hearing on the matter. Accordingly, I will be dissenting on this proposed order.
Thank you, Commissioner Coleman. Any further discussion?
I wish to associate myself with the statement of Commissioner Coleman.
Thank you, Commissioner Kennard. Any further discussion?
Yeah, Madam Chair.
Commissioner Sweet.
I don't want to prolong this, but let me just say that we're all kind of prisoners of our own experience. And I personally have been in the waiting area of the PUC, which is also an area in the Philadelphia office that folks who have matters or hearings before the Department of Health and Human Services are required to gather. At the time this incident occurred, there was no person at a desk. There was no human being that you could report to, and all the offices are locked off. By the way, that situation has been since corrected, and there is an attendant at that office to respond to various inquiries. But I personally showed up one day. In fact, this happened twice. I'll show you how absent-minded I am. Twice I didn't have my badge and attempted to get entry to the Philadelphia PUC office. And it took me many more than 20 minutes to finally get someone on the phone. In fact, I think I called here and people called down there, and there was a flurry to finally get me into the office. So I find some credibility to the assertion that you could be out in that waiting room and you could be unable to attract the attention of anyone in order to get in the room. So because of that knowledge that I have about that particular situation, I'm willing to give this complainant, I guess, depending on how you count, either a second or a third bite at the apple to actually make their case. Thank you.
Thank you, Commissioner Sweet. Any further discussion?
If I may, I'd also associate myself with Commissioner Sweet, having also been through the labyrinthine offices in Philadelphia.
Thank you very much. If there's no further discussion, all those in favor say aye.
Aye.
Any opposed?
Opposed?
The motion passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Kennard.
Continuing on page 6, it is recommended that the Commission adopt the proposed opinion and order regarding the complaint of Sherry and Lenny Trocchi versus the UGI Penn Natural Gas Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by Vice Chairman Place. Any discussion? Hearing none, all those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning to page 7, it is recommended that the Commission adopt the proposed opinion and order in the application of the Laurel Pipeline and Buckeye Pipeline Companies.
Is there a motion to adopt the staff recommendation?
So moved.
Second?
Motion by Commissioner Sweet, second by Vice Chairman Place. Any discussion? I do have comments to submit for the record. I would ask that they be submitted in their entirety, and I do have a summary of them. On November 14, 2016, Laurel Pipeline Company filed an application seeking to change the directional flow of petroleum products that are transported on a portion of its system west of El Dorado, Pennsylvania. This apparent simple change from east west to west-east turned out to be anything but simple. Shippers from the eastern part of the state that depend on the pipeline to transport product to the large Pittsburgh market hotly contested the application, while refineries and marketers moving petroleum from the Midwestern part of the country zealously advocated for the change in course, citing to the claims of lower cost supply from the Midwest. This is not an easy decision in that the parties on both sides of this proceeding have expensive vested interests in the outcome. However, based on the thorough record developed by Administrative Law Judge Farrell, and I do congratulate the judge for such a thorough record, and the well-written opinion and order drafted by our Office of Special Assistants, I also thank them and congratulate them as well, I am able to make an informed decision. Any abandonment of public utility service essentially comes down to the best interest of the utility company versus the best interest of the customers. Although Laurel argued that it would be more advantageous to the company to transport products from the Midwestern refineries, it did not provide any evidence showing why a change in rates was not also a viable option for its bottom line. Based on the record, it is clear that the eastern shippers will be negatively affected by the loss of public utility service as their product will dead end in the mid-state, leaving many of the option of trucking supply to Pittsburgh. Furthermore, the Pittsburgh and Western Pennsylvania market will be detrimentally affected by the loss of competition that the Philadelphia refineries provide to discipline Midwestern market forces. And for these reasons, I am voting to deny the application. Any further discussion?
Madam Chairman, I agree with what you've said. I too was persuaded by the customer interest in the continued westerly flow of this pipeline, and therefore I also intend to agree with the ALJ and our staff recommendation.
Thank you very much, Commissioner Kennard. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing on page 7, it is recommended that the commission adopt the proposed opinion and order in the case of Irwin Fox versus Verizon, Pennsylvania.
Is there a motion to adopt staff recommendation?
So moved. Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 8, it is recommended that the commission adopt the proposed opinion and order in the matter of the Bureau of Investigation and Enforcement versus Raymond Whitaker.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion?
I have a motion, Madam Chair.
Commissioner Sweet.
Thank you. This matter comes to us on a petition for reconsideration of staff action filed by Raymond Whitaker in response to a secretarial letter of August 1st, 2017, which directed the payment of a civil penalty of $1,000 for owning and operating a motor vehicle which had affixed to the roof a taxi dome light, clearly displaying the word taxi, while not certificated as a motor carrier. Mr. Whitaker did not respond to the complaint, and default judgment was entered against him. In his letter petition for reconsideration, Mr. Whitaker asks that the commission rescind the civil penalty because he thought he had taken care of the underlying complaint when he paid a civil penalty for 2 prior citations. In addition, he claims hardship. In reviewing Mr. Whitaker's history with the commission, it appears he deliberately purchased the dome light from Amazon and was cited twice prior to this complaint for holding himself out as a certificated taxi driver. He did pay the prior civil penalty, but as is evident, this failed to deter him from committing the same infraction again. The commission is charged with establishing and enforcing the statute and regulations which are designed to ensure that taxi services are properly financed, compliant with safety regulations, and insured. Mr. Whitaker is acting outside those regulations, and it is imperative that he understands the seriousness of the offense. Accordingly, I move that his petition for reconsideration be denied, that the full amount of the civil penalty remain assessed. Mr. Whitaker is warned that the penalties will continue to rise if he continues to violate the Commission's regulations. Therefore, I move that 1, the petition for reconsideration of staff action filed by Raymond Whitaker at this docket be denied. 2, that the Office of Special Assistants prepare an appropriate order consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion on the motion? Hearing none, all those in favor say aye.
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 Any opposed? The motion passes 5-0 without objection. If there's no objection, we'll take the previous roll call. Seeing no objection, the matter as amended passes 5-0.
Continuing on page 8, it is recommended that the commission adopt the proposed opinion and order in the matter of Benjamin Sagasi versus the Pennsylvania Electric Company.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Under discussion, I do have a statement. I ask that it be spread upon a record in its entirety, and I do have a summary of it. On March 6, 2017, Mr. Sagasi, and I thank you for giving me the proper pronunciation of that name, filed a complaint alleging that Penelec was threatening to terminate his electric service and that there were incorrect charges on his bill. The hearing was convened as scheduled, but the complainant failed to appear. On June 6, 2017, the initial decision dismissed the complaint with prejudice. The complainant filed exceptions on July 3, 2017. The complainant explained in his exception that he was disoriented on the day of the hearing due to a condition that he suffers from, and consequently, he made the mistake of relying on documents he received from the company rather than the documents he received from the commission. As a result, the complainant claimed he failed to pay attention to the instructions for dialing into the telephonic hearing and instead waited for the ALJ to call him directly. Pursuant to Section 332F of the Public Utility Code and Section 5.245 of our regulations, when a party fails to attend a scheduled hearing, such failure to appear will be deemed a waiver of the party's opportunity to participate in a hearing unless the failure was unavoidable. Here I do not believe that the complainant's absence was unavoidable. Therefore, the complaint should be dismissed. However, which has been my long history of the however, because he was a pro se complainant, I do not see the need for, and I didn't see any abuse of the administrative process. I'm not sure that the dismissal should have been with prejudice. I will concur in the result, but I do note my concerns that it should have been just a dismissal and not one with prejudice. Any further discussion?
Yes, if I may have a statement on the matter.
Vice Chairman, please.
I do believe that Mr. Sagasi should be afforded due process for his complaint to be heard by this commission. According to the complainant in this proceeding, he was ready to participate in the scheduling hearing, but misunderstood who was to make the call to begin the telephonic hearing. It is not unusual for pro se complainants to be confused by the administrative process of the commission's proceedings and should be an exculpatory rationale for avoiding dismissal with prejudice. As a personal note, also as someone who has an elderly parent, I get this. I can imagine. I'm not surprised that this does occur. So prejudice seemed a bridge too far. So with that said, I will be dissenting on this matter.
Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
Opposed?
The motion passes 4-1, noting the dissent of Vice Chairman Place.
And the last item on page 8, it is recommended that the commission adopt the proposed opinion and order in the case of Robert Benelli versus the Metropolitan Edison Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 9, it is recommended that the commission adopt the proposed opinion and order in the application of Aqua Pennsylvania wastewater.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
Madam Chair, I have a conflict statement. I'd ask that that statement be entered in the record as though I read it in entirety. Before joining my staff, Phil Kirkner worked in our Bureau of Investigation Enforcement, and my statement is basically indicating that Phil did not advise me on this matter.
Thank you. Any further discussion?
Madam Chairman, I have a conflict statement on behalf of my staff member, Rachel Maurer, who also worked for I&E on this matter, assuring the parties that she did not advise me on this matter and asking it be entered in, that my statement be entered in the record as if I had read it in its entirety. I have another statement that I asked be entered into the record as if I had read it. And basically, I wish to thank all the parties, Aqua, I&E, and the Consumer Advocate for settling this long-fought case, to addressing principles that will serve us well going into the future as we continue to implement the legislative intent behind Section 1329 of the Public Utility Code. And my heartfelt thanks to the parties for their flexibility and the guidance they provided to us for the cases moving forward. Thank you.
Thank you, Commissioner Kennard. Any further discussion?
I also have a statement on the matter.
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I'd read it in its entirety. Before us for disposition is the joint petition for resolution of proceedings and amendment of the opinions and orders entered November 29, 2017 and April 19, 2018 of Aqua Pennsylvania Wastewater Incorporated, Limerick Township, in the Office of Consumer Advocate that was filed on June 7, 2018. This settlement proposes the resolution of certain issues and its adoption will lead to the withdrawal of an OCA appeal that is currently pending before the Commonwealth Court. I recognize that the settlement addresses in a positive manner several issues that are relevant to the valuation of municipality and municipal authority water and/or wastewater assets that are being or will be acquired by Aqua PA under Section 1329 of the Public Utility Code. The proposed disposition of these issues will be applied to future acquisition transactions under Sections 1102 and 1329. However, the proposed settlement does not sufficiently address my material concerns regarding the absence of net affirmative benefits for Aqua PA's acquisition of the Limerick wastewater system that I expressed in my original dissenting statement when this acquisition was originally approved. The proposed settlement would only postpone the substantial revenue requirement and rate effects of the Limerick wastewater system asset acquisition, inclusive of the sizable 39.48% acquisition premium of $18.22 million. Eventually, both the Limerick system ratepayers as well as the Aqua PA wastewater and water service end user customers will have to bear the substantial cost burdens associated with this acquisition on a going forward basis without realizing any corresponding affirmative net benefits from this transaction. For these reasons, I cannot support the result of the proposed settlement.
Thank you very much. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
Opposed?
The motion passes 4-1, noting the dissent of Vice Chairman Place.
Continuing on page 9, it is recommended that the Commission adopt the proposed opinion and order in the case of Simmons, Wisenat, and Mowry versus UGI Utilities.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
5-0. Yes, ma'am. Turning to page 10, it is recommended that the Commission adopt the proposed opinion and order in the case of Clem Maribel versus the Philadelphia Gas Works.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second?
Motion by Commissioner Sweet, second by Commissioner Coleman. Any discussion?
I have a motion to present, Madam Chair.
Commissioner Sweet.
This is a joint motion of myself and Commissioner Kennard, and I ask that the motion be placed upon the record as if it had been read in its entirety. This case, and actually the following two cases, are here on the exceptions filed by each complainant to the initial decision of an administrative law judge, which dismissed each case after the complainants failed to appear for their evidentiary hearings. Also, in each case, the complainant received hearing notices and pre-hearing orders, which informed the parties of their duty to either attend the hearing or to seek a continuance prior to the hearing, and in each of the three, the complainant failed to do so. We recognize there are instances when appearance is both unavoidable and last minute, and in which case the complainant needs to contact the Office of Administrative Law Judge immediately to inform the ALJ of the situation. Under the right circumstances, the ALJ has the discretion to reschedule the hearing. Here, however, in all three of these situations, they failed to contact the administrative law judge and awaited until after the initial decisions had been issued. Unfortunately, they chose to plead their cases in exceptions instead after the fact, and the matter had already been removed from the Office of Administrative Law Judge. In each situation, the complainants failed to present any reason why they did not contact the Office of Administrative Law Judge, while that office still had the ability to evaluate their reasons and to reschedule the hearings if found appropriate. Accordingly, the initial decisions should be adopted. Therefore, we move that the exceptions, in this particular case, the exceptions filed by Clem Maribel to the initial decision of Administrative Law Judge Benjamin J. Myers are denied, that the initial decision of the Administrative Law Judge is affirmed, and that the Office of Special Assistants prepare an order consistent with this motion. Thank you.
You have heard the joint motion of Commissioner Sweet and Commissioner Kennard. Is there a second to the motion?
Second.
Second by Commissioner Coleman. Discussion on the motion. I do have comments to be placed on the record and ask that they be placed on the record in their entirety. In terms of this motion, I struggle with this motion because in terms of the complaining actually giving a reason for why he missed the hearing, he actually did give a reason. In his exceptions that are now before us for consideration, the complainant claims that he missed the August 14, 2017 hearing due to hospitalization. If the complainant's claim is true, then his failure to appear at the hearing was unavoidable. Pursuant to Section 332F of the Code and Section 5.245 of our regulations, when a party fails to attend a scheduled hearing, such failure to appear will be deemed a waiver of the party's opportunity to participate in a hearing unless that failure was unavoidable. I believe that this complainant should be given 10 days to submit proof of his claim that he missed the hearing because he was hospitalized. If the claim is substantiated, the matter should be set for hearing. If not, then the matter should be dismissed. I do not agree that this case should be dismissed without allowing the complainant an opportunity to support his claim. I can truly say that I was hospitalized. The last thing on my mind would be somebody called the PUC to say I can't make the hearing. So with that, I will be dissenting on the motion. Any further discussion? Hearing none. On the motion, all those in favor say aye.
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 Any opposed?
Opposed?
I also will be opposing. The motion passes 3-2, noting the dissent of Vice Chairman Place and myself.
Continuing on page 10, it is recommended that the commission adopt the proposed opinion and order in the case of Alice Anderson versus the Pico Energy Company.
Is there a motion to call up the matter for consideration?
So moved.
Second.
I just love this. Okay. So who am I supposed to pick from?
I don't think there's any
Couldn't do
bonus,
anything.
so I don't
Okay.
care. I'll yield.
Okay. Moved by Commissioner Kennard, second by Commissioner Coleman. On the matter, is there any discussion?
Yes, Madam Chair. Again, I have a joint motion with Commissioner Kennard.
Commissioner Sweet.
Thank you. I ask our motion be placed upon the record if it's read in its entirety. Consistent with the prior oral statement that I just made in the previous case and that motion, we believe that the initial decision of the Administrative Law Judge should be adopted, and therefore move that the exceptions filed by Alice Anderson to the initial decision of Deputy Chief Administrative Law Judge Christopher Pell are denied, that the initial decision of that judge is affirmed, and that the Office of Special Assistants prepare an appropriate order consistent with this motion.
You've heard the joint motion of Commissioner Sweet and Commissioner Kennard. Is there a second?
Second.
Second by Commissioner Coleman. In terms of discussion, I have a very similar statement because this is a very similar case. Once again, this complainant claims that she was hospitalized and that way she was not able to attend or participate in the hearing. So with that, my statements say that I believe that the complaint should be given, as I stated in the previous case, 10 days to submit proof of the claim that she missed a hearing because she was hospitalized. If the claim is substantiated, the matter should be set for a hearing. If not, then the matter should be dismissed. I don't agree that the case should be dismissed without allowing the complainant an opportunity to support her claim that her failure to appear was unavoidable. And I know that I summarized that and I asked that my full statement be submitted into the record in its entirety. Any further discussion? Hearing none. On the motion, all those in favor say aye.
Aye.
Any opposed?
Opposed?
I also will be opposing. The matter passes 3-2, noting the dissent of Vice Chairman Place and myself, and on the matter as amended, which I failed to do in the last matter. Forgive me.
It's all right.
If there's no objection, we'll take the previous roll call. I don't think there is an objection. So the matter as amended in the Alice Anderson versus Pico Energy Company case passes 3-2, noting the dissent of Vice Chairman Place and myself.
And finally, on page 10, it is recommended that the commission adopt the proposed opinion and order in the case of Robert Stridio versus PPL Electric Utilities.
Is there a motion to call up the matter for consideration?
So moved?
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Any discussion?
One more motion, Madam Chair.
One more. Is this your last one for the day? You don't know. Okay.
Let me look.
He's on a roll.
Maybe I'll,
Commissioner Sweet,
I'll think up one.
you are entitled to do as many motions as you want.
Thank you. I'm glad that there's not a quota because I would be censured constantly. Again, I would ask that my motion be read into the record as though I'd read it in its entirety. Again, it's consistent with my previous oral statement. We believe that the initial decision of the administrative law judge should be adopted. Therefore, we move that the exceptions of Robert Stridio to the initial decision of administrative law judge David Salapia are denied, that the initial decision of the judge is affirmed, and that the Office of Special Assistance prepare an order consistent with this motion.
You have heard the motion, the joint motion of Commissioner Sweet and Commissioner Kennard. Is there a second?
Second.
Second by Commissioner Coleman. Any discussion? I do have comments to be placed on the record and ask that they be placed on the record in their entirety. And I will summarize my comments. On November 6, 2017, Robert Stridio filed a complaint alleging that PPL was planning to terminate his electric service, that PPL employees refused to respond to inquiries about his account, and asking for a payment arrangement. The complainant failed to appear at the hearing. On February 14, 2018, the administrative law judge dismissed the complaint with prejudice for failure to prosecute. On February 22, 2018, the complainant filed exceptions arguing that on the day of the telephonic hearing, he fell suddenly ill and was unable to participate in the hearing. I believe that the complainant provided enough information in his exceptions to demonstrate that he experienced a medical emergency on the date of the hearing and that he was not medically capable of appearing at the scheduled hearing. Accordingly, I believe that the complainant's exceptions should be granted because it appears his failure to appear at the scheduled hearing was due to an unavoidable circumstance, which is consistent with Section 332F of the Code and Section 5.245A of our regulation. Additionally, I have previously expressed concern regarding the Commission's practice of dismissing pro se complaints with prejudice as being inconsistent with Section 1.2 of our regulations and the Commission's own case precedent regarding due process. In cases where there is no reason to suspect that the Commission's administrative process is being abused, dismissing without prejudice protects the complainant's right to due process while respecting the Commission's administrative process, and therefore I will be dissenting in the motion. Any further discussion on the motion? Hearing none. All those in favor say aye.
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 Any opposed?
Opposed?
I also will be opposing. The motion passes 3-2, noting the dissent of Vice Chairman Place and myself. on the matter as amended. There's no objection. We'll take the previous roll call. Seeing no objection, the matter as amended passes 3-2, noting the dissent of Vice Chairman Place and myself.
Turning to page 11, and matters presented by Director Diskin and the staff of the Bureau of Technical Utility Services. It is recommended that the Commission adopt the proposed order regarding the letter of notification filed by PPL.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Under discussion. Any discussion?
Yes, if I may have a motion on this.
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my motion be placed in the record as if I had read it in its entirety. Before the Pennsylvania Public Utility Commission is the letter of notification of PPL Electric Utilities Corporation requesting Commission approval to rebuild the existing 6-mile-long single-circuit transmission Briningsville, Alberta's 500 kV transmission line in Lower Macungie and Upper Macungie Townships, Lehigh County. The proposed project will rebuild the current transmission line into a double-circuit transmission line and includes the replacement of all 27 existing transmission line structures and the installation of 2 new structures. PPL estimated the total cost for the proposed project to be $33 million. PPL states that the addition of the second circuit and switchyard reconfiguration will enable it to resolve an existing NERC standard violation regarding voltage drop on the 138 kV and 69 kV systems during a contingency event. PPL further states the proposed project will enable it to bring its Westcoastville substation up to current design standards. According to the utility, the proposed project will improve the reliability of the Briningsville substation by providing a third 500 kV source. Currently, the Briningsville substation has 2 sources, the Westcoastville-Briningsville 500 kV transmission line and the Briningsville-Albertus line. PPL avers that during maintenance scenarios when one of the 2 500 kV transmission lines is taken out of service and a fault occurs on the other transmission line in service, the entire Briningsville substation loses power. This is often referred to as an N-1-1 condition, where 2 combined system outages happen in close proximity in time. PPL states that the addition of a third 500 kV source will avoid interruptions during maintenance of those 500 kV lines and for certain contingency events. The addition of the second 500 kV circuit to the existing Briningsville-Albertus transmission line was presented to the PJM Mid-Atlantic Sub-Regional Transmission Expansion Plan Committee and approved as supplemental project. Under the Commission's siting regulations, the company must establish a clear need for the project. PPL has not adequately proven the need for this project through its filings and data request responses. Specifically, the company has not established a reasonable likelihood that the alleged events leading to an outage event are likely to occur, nor has it demonstrated the proposed solution is an efficient and cost-effective choice relative to other alternatives. It should be noted that I do not take this action lightly. However, this filing presents some rather unique circumstances, including replacement of a well-functioning facility well before the end of its full life expectancy, failure to fully resolve a potential threat that PPL alleges to fix, failure to reasonably quantify the alleged reliability benefits of the project, and failure to fully assess alternative solutions to the alleged reliability issues. Given these shortcomings, I conclude that this project clearly distinguishes itself from previous projects that I have voted affirmatively. This Commission has a responsibility to ensure that substantial investments are prudently made, particularly those filed as supplemental projects. Because this is a supplemental project, no other third party, such as PJM, has performed a cost-benefit analysis or assessed alternatives. Moreover, PPL has filed a vastly disproportionate number of such supplemental projects. As of August 30th, 2017, the company was responsible for $2.9 billion of the $3.1 billion to be spent on supplemental projects in Pennsylvania, or 93% of such spending. According to the annual rate comparison report, PPL's transmission rates have increased 175% since January 31st, 2006, with almost all of that increase starting in 2013. Between 2013 and 2018, PPL's transmissions rates increased 19% each year. While this history and inventory of past and future transmission project costs do not have a direct relevance to the particular circumstances to this proposed project, they do highlight the need for further scrutiny by all interested parties to ensure the regulatory requirements are met, particularly for supplemental projects, and the electric distribution companies in Pennsylvania are expected to provide more information to justify these expenditures going forward. Based on the discussion above, I recommend denial of the proposed lawn application. Given PPL's failure to demonstrate the need for the proposed project and to examine available alternatives, I must deny PPL's lawn and direct PPL to comply with the application process set forth in our regulations. To the extent the company provides its lawn or files an application and thus provide evidence that this project is an optimal means to enhance reliability in its transmission and distribution system in a cost-effective manner, I'm always open to reconsideration. However, at the current time, PPL has not carried its burden to prove the need for this project and available alternatives. Therefore, I move that 1, the letter of notification of PPL Electric Utilities for approval to rebuild the existing Bridningsville, Alberta's 500 kV transmission line in Lower Macungie and Upper Macungie Townships, Lehigh County, Pennsylvania, be denied. 2, PPL Electric Utilities comply with the application process set forth in 52 PA Code. And 3, Commission's Bureau of Technical Utility Service prepare an opinion and order consistent with this motion. Thank you.
You've heard the motion of Vice Chairman Place. Is there a second?
Second.
Second by Commissioner Sweet. Any discussion?
Chairman, I do have a statement on this matter.
Commissioner Coleman.
Thank you. I'd ask that my statement be entered to the record as though I read it in its entirety. As indicated in the motion this morning, this is a request from PPL that's seeking authorization for the reconstruction of the above referenced section of a high voltage transmission line. It has requested approval through a somewhat abbreviated process known as the letter of notification, or LON, which allows for by regulations of this commission. The commission has the discretion to approve the siting and construction of a high voltage transmission line through the LON process, as you've heard, provided that certain elements have been satisfied. Based upon the information provided thus far, I believe the PPL has not satisfied those elements. Therefore, I concur in result of the proposed motion, which will require the PPL be directed to use the full siting application process of our regulations. It's important to note that it's through this process PPL will have the opportunity to provide more information on the project before the Commission makes a final decision on the merits of this case. As with any proceeding, I will review the record that is developed and then render a decision as to whether the evidence shows that PPL has satisfied the applicable criteria for this approved project. So again, I'd emphasize that I'm concurring in result only on this matter. Thank you, Madam Chair.
Thank you, Commissioner Coleman. Any further discussion on the motion?
Madam Chairman, I do not have a written statement, but I do want to say, while I appreciate the intent to apply additional scrutiny to letters of notification going forward, I also perceive that we are undertaking a change in our historic policy. We have not previously ever, in my knowledge, disapproved a letter of notification. It is only fair under those circumstances to have an open public discussion before we do so. Staff recommends approval of this LON, and I intend to vote with the staff on this matter.
Thank you, Commissioner Kennard. Any further discussion on the motion? Hearing none. All those in favor say aye.
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 Any opposed?
Opposed?
The motion passes 4-1, noting that Commissioner Kennard will be dissenting and noting that Commissioner Coleman is voting in the result only. On the matter as amended, is it okay to take, is any objection to taking the previous roll call? Hearing none, the matter is amended with all the different qualifiers that I added before, passes 4-1.
Continuing on page 11, it is recommended that the Commission adopt in an omnibus motion the 3 remaining items on page 11, all of the items on page 12, and the first item on page 13 regarding the security certificate of UGI utilities.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
And the last item on page 13, it is recommended that the Commission adopt the proposed order regarding the disposition of an existing rail crossing.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Under discussion, I do have comments to be placed on the record, ask that they be placed on the record in their entirety. Before the commission is an investigation with respect to the crossing where Maple Glen Road crosses a simple track of Norfolk Southern Railway Company in the borough of Centerville, which is in Washington County. The action taken today refers the matter to our Office of Administrative Law Judge to schedule a hearing for the purpose of receiving testimony related to all matters pertaining to the subject crossing, including determining appropriate jurisdiction. Due to the immediate safety concerns regarding the current conditions of the crossing, I just want to encourage all the parties to resolve this matter as expeditiously as possible. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 14, in matters presented by Chief Counsel Padque and the staff of the Law Bureau, it is recommended in an omnibus motion that the commission adopt the first two items on page 14.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing on page 14, it is recommended that the commission adopt the proposed order regarding the rulemaking to comply with competitive classification of telecom retail services.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
Chairman, I do have a statement on this matter.
Commissioner Coleman.
Thank you. I'd ask that my statement be entered in the record as I read it in its entirety. This is the continuation of an action that this commission took back in February of 2015, and being the last man standing from that action when we agreed to allow Verizon some waiver from our Chapter 3 and Chapter 64 regulations in competitive wire centers. This morning is a continuation of that and looking at advancing a notice of proposed rulemaking on those matters. I think the important point to underscore today is this commission's ability to recognize the economic realities of what's happening in the marketplace, particularly around wireline communications and the precipitous drop in those that are using those types of services, and recognizing that technology has advanced dramatically, not only here in Pennsylvania, but really across the country. I view this rulemaking as a continuation of those efforts to modernize how we regulate telecommunications here in Pennsylvania. The telecommunication marketplace continues to be dynamic and fast-changing segments of our economy. The communication options for consumers has expanded beyond traditional voice-only service offered to incumbent carriers. With the proliferation of service bundles and the rise of alternative wireline providers and wireless providers offering competitive products and services, consumers have a wide array of choices to meet their communication needs. The initiation of this rulemaking is an important step toward ensuring that our regulations keep pace with those market realities. Thank you, Chairman.
Thank you, Commissioner Coleman. Any further discussion?
I also have a statement on this matter.
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I read it in its entirety. As noted, this advanced notice of proposed rulemaking proceeding is largely rooted in the Commission's 2015 landmark Verizon reclassification order, where the Commission classified the basic local exchange services in 153 wire centers of Verizon Pennsylvania LLC and Verizon North LLC as competitive under the statutory requirements of Section 3016A of the Public Utility Code. The potential expansion and applicability for the waivers of our regulation that are contemplated in the NOPR can and will have impacts in matters where the Commission exercises regulatory oversight, such as the quality and reliability of service and consumer protection. I note that in the context of its Verizon reclassification decisions, the Commission directed the collection and evaluation of certain data. It is my sincere hope that, consistent with all the applicable Commission orders in the Verizon reclassification proceeding, the interested parties will properly utilize the data submitted by Verizon in conjunction with their respective comments on the contemplated extension and permanent application of the waivers at issue for the Verizon wire centers. Furthermore, similar data that has been elicited in our proceedings, inclusive of follow-up reports, should also be utilized for the same purpose. I would also like to invite comments on the SNOPR explaining how other states have recently chosen to modernize their respective regulations governing the provision of retail telecommunication services, with special emphasis on regulations which deal with reliability and quality of service and consumer protections. Finally, I note that the competitive classification of protected basic local exchange services that are provided by incumbent local exchange carrier telephone companies with carrier of last resort obligations is subject to the statutory requirements of Section 3016A, including appropriate findings of sufficiently competitive markets in the presence of substitute telecommunications services. This can materially affect the process and the future applicability of certain regulation waivers that were subject to the Verizon reclassification order. Thank you.
Thank you very much, Vice Chairman Place. I also have comments to be placed on the record. I would just read mine in its entirety because they are brief. On March 4th, 2015, the Commission entered an opinion and order reclassifying 153 of Verizon's 194 wire centers as competitive pursuant to Section 3016A of the Public Utility Code. That decision, which I dissented from, also granted a 5-year waiver of certain of the Commission's chapters 63 and 64 regulations in the 153 wire centers classified as competitive, pending a rulemaking to address the status of the regulations applicable to non-competitive and competitive wire centers. So this rulemaking proceeding will consider the regulations applicable to the competitive and non-competitive wire centers. The regulations adopted for non-competitive wire centers are distinct from regulations applicable to wire centers classified as competitive under Section 3016A. And the reason for my statement is that, for the record, I would like to clarify that it is my view that the Commission cannot develop rules for competitive wire centers and apply them to non-competitive wire centers without the prior reclassification determination required for the non-competitive wire centers under Section 3016A. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 15, and matters presented by Chief A.L.J. Rainey in the Office of Administrative Law Judge. It is recommended that the Commission adopt A.L.J. Salapa's recommended decision in the matter of core communications.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Vice Chairman Place. Any discussion?
Madam Chairman, I am recusing myself from voting on this matter inasmuch as I was previously involved in it when I was in private practice.
Thank you, Commissioner Kennard. Any further discussion?
Also, Madam Chair, before joining my staff as legal counsel, Regina Matz was an attorney in private practice who had entered an appearance in and worked on this case. Please note she has not advised me on this matter.
Thank you very much. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 4-0, noting the recusal of Commissioner Kennard.
At the bottom of page 15, it is recommended that the Commission adopt A.L.J. Gould's initial decision in the case of Philadelphia Gas Works versus William Madison.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second. There was a joint second by Vice Chairman Place and Coleman. Any discussion? I do have a comment to be entered into the record in its entirety. The ALJ in this case determined that Mr. Madison is responsible for the total bill for unauthorized usage from July 14, 2006 to August 25, 2016 in the amount of $5,482.33. I agree with the ALJ's disposition of this complaint. However, I must also express concern that PGW appears not to have adequately monitored its facilities at this property for a decade. As I have done in the past, I wish to emphasize to PGW and all of our natural gas distribution companies the importance of routinely monitoring all of their facilities to determine occurrences of theft of services. To the extent our utilities have not already done so, I strongly recommend that they establish an internal policy to effectively monitor dormant accounts for unauthorized use. Theft of service not only hurts the companies and the ratepayers financially, it imposes a danger to the public at large due to the likelihood of gas leaks. I believe that under Section 1501 of the Pennsylvania Public Utility Code, our natural gas distribution companies have a duty to monitor their distribution facilities regardless of whether there is an active account attached to them. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 16, it is recommended that the commission adopt ALJ Watson's initial decision regarding Alexandre Forsevich versus the Metropolitan Edison Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the commission adopt ALJ Salapa's initial decision in the matter of April Jackson versus the Duquesne Light Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion on this? I do have a statement to enter into the record in its entirety. Before the commission today is the formal complaint of April Jackson against Duquesne Light Company. Duquesne filed preliminary objections claiming that the complaint is insufficiently specific. The ALJ dismissed the case because no amended complaint was filed. The ALJ ignored the precedent of Elliott versus Pico Energy Company and relied on subsequent decisions dismissing the complaints on the matter. Later revisions in the commission's complaint form after Elliott notified complainants that their case may be dismissed without a hearing if specific information is not provided. Neither the revised form nor subsequent precedent should stand for the proposition that parties well-versed in legal administrative practice can avoid substantive consideration of pro se claims with procedural devices to secure dismissal without a hearing. This undermines the legal principle that pro se litigants are given considerable leeway in court and agency proceedings given their lack of legal sophistication. This commission has long recognized the mitigating effect that pro se status confers upon litigants unlearned in the law. The commission has stated that it is in the public interest that all litigants, particularly pro se litigants, be afforded a meaningful opportunity to be heard. Dismissing pro se litigants without hearings because they fail to meet the exacting practices and expectations reserved for parties represented by counsel is inequitable and should be avoided when possible. And so therefore, I will dissent on this case. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? I will be voting no. The motion passes 4-1, noting my dissent.
It should be noted that the last item on page 16 has been postponed until the public meeting of August 2nd. Madam Chairman, that concludes the regular agenda. We now turn to the carry-in agenda. On page 1, it is recommended that the commission adopt the proposed opinion and order by the Office of Special Assistance, granting the petition pending review on the merits in the matter of Mary Paul versus the Pico Energy Company.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to the Bureau of Technical Utility Services, it is recommended in an omnibus motion that the Commission adopt the proposed orders regarding the rate proposals filed by the Pittsburgh Water and Sewer Authority, appearing at the bottom of page 1 and at the top of page 2 of the carrying agenda.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
And finally, on page 2 of the carry-in agenda, it is recommended that the Commission adopt the proposed order by the Law Bureau regarding the initiation of a rulemaking into the Commission's jurisdiction over poll attachments from the FCC.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
I have a statement.
Commissioner Sweet.
In the order we're adopting today, this commission opens a proposed rulemaking to consider adoption for use under the commission's state jurisdiction, the current rules of the Federal Communications Commission applicable to issues involving poll attachments. As stated in this order, quote, by working to take this important issue in hand at the state level, the goals of this initiative will work to support the Commonwealth's effort to provide advanced telecommunications tools to its citizens. I'm prepared to move forward expeditiously to support this goal, but I'm compelled to express my concerns with the additional caseload and demands on the Commission's resources that this undertaking has the potential to impose. This impact on our resources has not yet been quantified, so at this point we have no idea the potential cost to the Commission of this undertaking, nor have we identified any new revenue sources, such as assessments under Section 510 of the Code, that will provide this Commission the revenues necessary to address these new responsibilities. These questions need to be fully explored and hopefully answered in the affirmatively in the process as it unfolds. Thank you.
Thank you, Commissioner Sweet. Any further discussion?
I also have a statement on the matter.
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I had read it in its entirety. Through the notice of proposed rulemaking order that is being advanced today, the Commission proposes to adopt the regulatory framework of the Federal Communications Commission and exercise state jurisdiction over the various issues that involve poll attachments, as noted. I note that these issues have a certain degree of complexity in terms of compensation as well as ordinary engineering, safety, and reliability. Similarly, multiple parties have numerous and often diverging interests. I also note that the FCC's regulatory framework for poll attachments does not extend to polls owned by municipal and cooperatively owned entities. Furthermore, there are several indications that the FCC's regulatory framework that is applicable to poll attachments will be subject to change in the near future. In view of these factors and future developments, interested parties in this rulemaking proceeding should provide substantive comments and/or reply comments on the following issues. 1. The legal and technical interactions and ramifications of any future Pennsylvania statutes that may address poll attachments with any potentially adopted Commission rules that are based on the FCC regulatory framework. 2. The technical and legal ramifications of adopting the FCC regulatory framework for poll attachments in Pennsylvania, while the FCC may proceed with future changes in its own regulations on poll attachments. Would the Pennsylvania poll attachment regulations be automatically linked with the corresponding FCC regulatory framework changes? Or will the Commission be obliged to institute a new rulemaking or other proceeding with appropriate due process notice and comment under applicable Pennsylvania law in order to consider such future changes in the FCC's own regulatory framework for poll attachments? 3. Whether the Commission's existing exercise of jurisdiction, including rate-making mandates over public utility entities that are and will be subject to poll attachment regulations, will present any unique issues that may require Pennsylvania-specific changes to the FCC's applicable regulatory framework. Thank you.
Thank you, Vice Chairman Place. Any further comments, discussion?
I do, Madam Chairman. I'd like to thank my fellow commissioners and the staff for bringing this important issue before us. And I also want to thank my colleagues for their thoughtful statements and questions. We have seen bipartisan support for this effort, And I'd like to thank everyone, including our friends in the General Assembly and in the Governor's Office, for their leadership and projected participation in this docket. I look forward to the continuing discussions and building those relationships through this rulemaking. I believe it works for the profound benefit of this Commonwealth, its residents, and both poll owners and poll attachers. In my statement, which I asked be read in the record, is entered into the record as if I had read it in its entirety, listed 7 areas of inquiry that I hope will help precipitate comment and suggestion from the public, industry, and all interested parties. Thank you, Madam Chairman.
Thank you. And let me just say, I also have comments for the record, and I appreciate your offer of thanks. And I just want to throw in my 2 questions that I would like to have asked as well. I asked that the parties in this proceeding to address developments on poll attachments that have occurred since the issuance of the FCC's 2011 poll attachment order, particularly how the Commission's adoption of the FCC rules should address rules that may not necessarily reflect a consensus view of Pennsylvania's providers. I also asked that the parties to address what, if any, impact the pending Broadband Deployment Advisory Committee, or BDAC, deliberations and recommendations will have on poll attachments in Pennsylvania. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? Motion passes 5-0.
Madam Chairman and Commissioners, that concludes the carried agenda and all agenda items for today's public meeting.
We thank you very much. If there's seeing no other matters to come before us,
None, ma'am.
the meeting is adjourned.
I gotta say.
Thank you very much. I got your comments.